Sha-la-la, sha-la-la-la-la-la, sha-la-la-la-la-la. Sha-la-la, sha-la-la-la-la-la, sha-la-la-la-la-la. Sha-la-la, sha-la-la-la-la-la, sha-la-la-la-la-la. Sha-la-la, sha-la-la-la-la-la, sha-la-la-la-la-la. Sha-la-la, sha-la-la-la-la-la, la-la-la-la-la. Sha-la-la-la, sha-la-la, sha-la-la-la-la-la, sha-la-la-la-la-la. Sha-la-la, la-la-la-la-la-la, sha-la-la, sha-la-la-la-la-la, sha-la-la, sha-la-la-la-la-la, sha-la-la-la-la-la. É muito linda, uma letra muito difícil de decorar.
That's funny. That's funny. Someone there was implying they've seen it before. I only stumbled on that like 15 minutes ago for the first time. I thought it was funny. Good evening, everybody. Welcome to the following program. I am your host, Joe Neerman, aka Good Lawgic. If you're a fan of the show, you know I probably are aware of the fact that I usually tend to cover a whole bunch of different topics when I'm doing a show. I'll usually fixate on 2, 3, maybe 4 topics on the outside. Sometimes I'll sprinkle in other side stories in order to, little tiny juicy nuggets that I think, are not big enough for me to actually reference in the title, but are important to call to your attention. Tonight's show is going to be a little bit different. I'm trying something out, something new. In fact, I'm trying a few things out new with this show for a bunch of different reasons that we're not going to get into. But one of the new things I'm trying out is tomorrow I plan on bringing in a new co-host who I'm hoping will just mix up the vibe here, because I think that experimentation in your podcasting is probably a healthy thing to do. So we're going to be trying him out. I think you guys are going to like him. My gut. That's my gut. I wouldn't be doing it if I didn't think you like him. I do have a goal tonight. Tonight's goal is, if we reach our goal, which is our standard goal of 15 yellows, that I have a doubt. I doubt we're going to make it. But if we hit 15 yellows tonight, I will certainly stream Ryan Ruth's live stream Ryan Ruth's trial. Now that's pretty big. That's a pretty big thing I'm taking on my shoulders, because for all I know, this trial is going to be boring as anything. But Ryan Ruth, you might know him as the would-be assassin of President Donald Trump. He was the one who was laying in wait at Trump's golf course. And supposedly he's representing himself. I believe they're in the middle of doing jury selection now, from what I see. I assume that it's being live streamed. I haven't really even been looking for it. Yeah. It's not Pisco. No, it's not Pisco. It's someone you're gonna like. It's not Pisco. No, I wouldn't call Pisco a co-host. I'm not telling you I'm never going to bring him back on here again. No, I'm not saying that. I'm just saying that, this is someone who I'm sort of, it's sort of like, I guess it's like an Ed McMahon type of role, just to show my age there. Or is it Andy Richter? It's an Andy Richter type of role. Is that showing my age? I think that's, Andy Richter type of role, I guess. There you go. To Conan. Was that? I think that's, yeah. Anyway, we'll try it out. I like mixing things up and experimenting. Anyway, so that is our goal for tonight. that if we reach our goal, then I will certainly live stream the Ryan Ruth trial. If we don't reach it, I may or may not. I may or may not. It's very time consuming and very exhausting live streaming trials. We will see. We will see. Anyhow, tonight's topic, instead of doing multiple topics tonight, there's really just one I'm fixating on, and that's because the United States Supreme Court has granted expedited certiorari with respect to Trump's tariffs. There are multiple cases that are going on with respect to the tariffs that Trump has levied on various countries across the globe. Initially, it was just on Mexico and Canada, and then he extended it with follow-up EOs. I think in total there were like 5 EOs that related to tariffs that Trump executed. And there are a number of different cases which are basically being glommed together and thrown together. And we're going to go through exactly what those tariffs were, what his argument was, what the legal basis was for those tariffs. And I want you to understand the legal arguments for and against the tariffs. I'm very curious whether you guys are in general in favor of the tariffs or not. I was traditionally someone who's very anti-tariff. I thought that tariffs, if you would have asked me 5 years ago, I would have been like, tariffs are bad, tariffs are bad. When Trump implemented these tariffs, I thought they were good. And I thought that I said, we don't know what's going to happen with the economy, but I think that Trump will be able to use them as a hammer in order to make our economy stronger and basically wield the economic might of the United States as a weapon and put America's interests first. And I have confidence in him that he's going to put American interests as opposed to Democratic presidents, the last 2 Democratic presidents we had, which seem to be very America last type of perspective. So I have a lot of confidence in him in that regard. Excuse me. My general policy with respect to these tariffs is I like them as an economic policy. I like them. I think they're really good. I think that I was like, look, could it harm the economy? Yeah, it could. I think so far they've been really a very big win for the United States by and large. And I want them there. I want them to stay. I am curious whether you guys agree with me on that. I'm going to put a quick poll up. I want them there just so I get a flavor for what you guys think. So let's do a quick poll up here, and you guys can answer that anytime. Do you like Trump's tariffs? I'll have yes, no, and very mixed. Now, this is not a question. When I'm asking this question, and you can answer in the ghetto if you're there, I'm going to be checking the ghetto too. Don't worry. And I want to apologize while I'm bringing up the ghetto. I want to apologize. I wanted to stream to the ghetto yesterday. I don't know if those of you who are in Rumble managed to catch my show on YouTube. I did live stream on YouTube yesterday. I wanted to live stream to Rumble, and I couldn't get it to load. Like I couldn't get to, and I showed my audience there how, for one reason or another, in order to set it up, if you're watching on Rumble, my stream on Rumble starts with a certain short clip video. You have to upload some video there in order to get your stream set up. And I couldn't get it to run. I couldn't get it to upload. And it just wasn't uploading. Normally it takes like literally 2 to 3 seconds for the entire video to upload. And it was sitting there for like 45 minutes. And I kept refreshing and trying, new tabs. Nothing was working. I couldn't get it to load. So I couldn't stream to Rumble. And I was very, very frustrated by that last night. Today it worked fine. It just uploaded in 2 seconds as usual. So I apologize to those of you in the ghetto. But I am checking you out to let me know if you think tariffs are good, bad, or your mixed feelings on it. That's the poll that I have up in tariffs are good. That's the poll that I have currently up and running in YouTube. I'm curious about your take on it. Now, my fixation tonight is not going to be as much as to whether people like them or dislike the tariffs, But I really want to break down the law and whether or not Trump is empowered to issue tariffs, what laws may seem to prohibit versus authorize him, what steps he took in order to try and find legal justification. You know, he's definitely gotten some criticism, not just from the left for imposing these tariffs, but many people in the MAGA camp like a lot, like Thomas Massey and Rand Paul, very vocal against the tariffs as being something that he's not empowered to do. And we're going to look at it. We're going to look at the law, because this is something that the Supreme Court is going to be looking at over the next couple of months. They have an expedited schedule where they told him to get his papers in within the next couple of weeks in defense of these tariffs, and gave the petitioners here a month to respond, and then they're going to have oral arguments in early November, and we should expect a decision on this relatively quickly. So these tariffs are very much in peril that they could be knocked out by the Supreme Court this year. It would not be remotely surprising if we got a decision from the Supreme Court this year, and if so, I want to sort of assess for you where I think the Supreme Court is likely to go. And so I'm going to break that down for you. So that's what we're doing tonight. It reminds me of my ex. I could parallel park a Mack truck. My ex used to jump out of the driver's seat and let me do it. He was a mess. Really? I've never heard of a wife who was better at parallel parking than her husband. What? What?
I'm really good at parallel parking.
Nah, look, I'm not saying you're a bad parallel parker. I never did any of you hear me say that Lady Logic is a bad parallel parker? Did not say that. No, I didn't say that. What I said was I've never heard of a wife who was a better parallel parker than her husband.
I think we should video this.
Oh.
I think we should have like a vote.
Seriously. Come on. There have been occasions, not often, once or twice, where you asked me to park it for you because it was that tight. It was that you're like, no. Okay. I literally taught you to drive. Now you know you're a very strong driver now, but I literally taught you to drive. This is what happened. No, I've never heard of this before. I've never heard of a situation like what Kimmy is describing here. I've never. No, it's not a matter of admitting it. It's a matter of spatial relationship, that men are more naturally attuned to having a spatial relationship. So there you go. No, there's a difference between not liking to drive and being bad at it. Those are two different things. I can be really, really good at needlepoint. That doesn't mean I want to do it. This is like... Gosh. One down. That's right. One down. You tell him, Morabata. This is what I like to see. One down. Thank you. Iowa Backyard. Remember, for 9 months, the best not a cult. And hit the freaking like. Hit the like. Jobs adjustment of 911,000. I was going to cover this. I was thinking about covering this. Yes. Everything about Biden was even worse than we thought it was. The Bureau of Labor Statistics lied about our jobs and claimed an extra 911,000 jobs, basically close to. And plus, there was earlier another 800,000. They overestimated jobs by somewhere between 1.4 and 1.7 million jobs. I mean, disaster. He was such a disaster. If we abolish the IRS now, the external revenue service is established, then they can tariff however they want. How it is now, though, we get zero. We're going to talk. Well, I'm not going to talk so much about the external revenue service. That I'm not going to be going into. But I do want to break down for you the EOs that were brought by Trump. And frankly, there were two different EOs that he brought. The first one, I don't actually have a copy of the first one. I saw it somewhere. Where did I see it? I think I saw it in Grok. Let me see if I can pull it up. Trump. Let me do this real quick. Tariff. Mexico. Okay. So this was the first one that he brought up. Let's go through historically what he did, because he did different ones and on different bases. And I think we're going to ultimately learn that the basis that he uses could be very, very critical as far as whether or not these are ultimately adjudicated to being legal tariffs or not. And I'm going to walk you through that because I want you all to really understand the legality of the tariff situation. Because I think that these tariffs are a very important element to our economy in a number of different ways, in ways that I think are potentially very, very positive. So I'm going to try and break it down for you what I think that the court may well focus on here. All right. So this was from February 2nd, 2025, imposing duties to address the situation on our southern border. What he basically said is, I, Donald Trump, President of the United States, find that the sustained influx of illegal aliens and illicit opioids and other drugs has a profound consequence on our nation, endangering lives and putting a severe strain on our healthcare system, public services, communities, and schools. Since the end of my first term, the U.S. Customs and Border Protection, the CBP, within the Department of Homeland Security, has recorded more than 3 times as many inadmissible encounters nationwide as during my first term. These challenges threaten the fabric of our society. Gang members, smugglers, human traffickers, illicit drugs of all kinds have poured across our borders and into our communities. Mexico has played a central role in these challenges, including by failing to devote sufficient attention and resources to meaningfully stem the tide of unlawful migration and illicit drugs. Mexican drug trafficking organizations are the world's leading traffickers of fentanyl, methamphetamine, cocaine, other illicit drugs, and they cultivate, process, and distribute massive quantities of narcotics that fuel addiction, violence in communities across the United States. These DTOs, the drug trafficking organizations, collaborate and conspire with transnational cartels and other global partners to smuggle drugs into the U.S. The Mexican DTOs have an intolerable alliance with the government of Mexico, meaning that they're basically being supported by the very government itself, and that alliance endangers the national security of the United States. And we must eradicate the influence of these cartels from the bilateral environment. I mean, we want to sever that. We want to discourage the government from working together with those cartels. The government of Mexico has afforded safe havens for the cartels to engage in the manufacture and transportation of illicit drugs, which have collectively led to the overdose deaths of hundreds of thousands of Americans. So he's basically blaming the Mexican government for fostering an environment which allows these drugs to flourish in our country. Mexican cartels also implicated in human trafficking, smuggling operations, enabling illegal migration of millions across our borders. Immediate action is required to address. I hereby determine in order that as President of the United States, my highest duty is the defense of the country and citizen. A nation without borders is not a nation at all. I think that's an eminently reasonable position for him to take. I will not stand by. I previously declared a national emergency, so he's restating his national emergency here. And pursuant to the NEA, I hereby expand the scope of the national emergency declared in the proclamation to cover the failure of Mexico to arrest, seize, detain, and otherwise intercept these drug trafficking organizations and basically holding them accountable. All articles that are products of Mexico as defined by the Federal Register shall be consistent with law subject to an additional 25% ad valorem rate of duty. So he's tacking on an added duty of 20, smacking Mexico with an added 25% duty. The rates duty established by this order are in addition to other duties, fees, exactions, or charges. Should the government of Mexico retaliate against the United States in response to this action, the president may increase or expand the scope of duties. So don't mess with us. If you try punishing us back, it's just going to get worse for you. So take your punishment, swallow it like a good little girl. As he's talking to Claudia Sheinbaum, the president of Mexico, in order to establish a duty rate on imports, etc. And that's basically the argument that he puts forward there for setting his Mexican duty. There were 5 EOs from what I saw in total. 5 EOs which basically address this. I'm going to look at one more real quick here as far as the argument that he made. This was on April 2nd, which was exactly 2 months later. President Donald Trump declares national emergency to increase our competitive edge, protect our sovereignty, and strengthen our national economic security. So over here, the first one was, we have this massive migration of people, an influx of people, a terrible influx of drugs. This is a way that we're trying, and this is how he's trying to address that problem. That is obviously not what he's going to say with respect to the rest of the world, because there's no connection. You can't blame Saudi Arabia for an influx of people across our border, right? You may be able to blame China for, some of the opioid and drugs, and perhaps, a lot of Chinese nationals coming across our border, but you can't blame every country in the world for that, right? Perhaps you can blame some Central American countries in addition to Mexico, as, we've heard him talk about Venezuela all the time. So in theory, he could extend that out as a basis for imposing tariffs on these other countries. With respect to this particular tariff, what he puts in here as his basis is, he says that large and persistent annual U.S. good trade deficits have led to the hollowing out of our manufacturing base, resulting in a lack of incentive to increase advanced domestic manufacture capacity, undermined critical supply chains, and rendered our defense industry base dependent on foreign adversaries. So he says he's going to put this order to impose responsive tariffs to strengthen our international economic position. And he's laying out here how our position has been weakened. So one of them is that we have trade deficits. He says President Trump invoking his authority on the International Emergency Economic Powers Act in 1977. And we're going to hear a lot about the IEEPA. This is a critical element that he relies on a lot, and he invokes a lot as justification for this. Why is it that he's the president of the United States? When I first heard about tariffs, I'll be frank with you, the first thought I have is, of course, he should be allowed to decide tariffs. Tariffs is related to international affairs. He's ultimately the final authority on that, and he should be the one who gets to decide what, if any, tariffs we would apply to other people. That clearly has a great deal to do with our relationship internationally, and that he should be the one to oversee that. However, as a constitutionalist, as I am, and I'm sure many of you are, I think that we need to recognize that under Article 1, Section 8 of the Constitution, he is somewhat limited unless Congress, in fact, gives him authority. I think it's Article 1, Section 8, Section 8, Clause 3. If we pull it up here, the Constitution, as drafted by our founders, says Congress shall have the power to regulate commerce with foreign nations. So while I would think he should have that power, if you actually read the Constitution, regulating commerce is something that is left specifically not to the president, but to Congress and among the several states and with Indian tribes. Supreme Court has interpreted the among the several states, etc., But this has been read to imply that when it comes to that, and this has been very clearly understood to mean that when it comes to imposing tariffs as a general rule, that duty, pardon the pun, falls exclusively to Congress. This is not Article 1 is governing the powers of Congress. Presidential powers come under Article 2. And Article 1 here says when it comes to regulating commerce, which would include duties, tariffs, that's congressional domain. Now, Congress has the right to cede that authority over to the President of the United States if they're so inclined. They have the right and authority and power by statute to come along and say, okay, we're going to allow the president, if he thinks that it's necessary to impose tariffs in various scenarios, to effectuate tariffs. That's what he's authorized to do. So that means now we have to start looking at statutes wherein Congress grants that authority to the President of the United States. And historically, there have been a number of statutes which have raised this issue, some of which basically ended up being sort of sunsetted out, or if not sunsetted out, laid to rest. Because under earlier presidents of roughly a century ago, I think it was Taft, Congress was not too happy with how they basically started, how the president started, what their opinion was, abusing the power they'd given the president to issue tariffs. So they started dialing it back somewhat, what kind of tariff powers they were willing to share with the president of the United States. So that led us to the IEP, oh gosh, I got it in my brain already. I knew this was going to happen. So that led us to the IEEPA being passed in 1972. So sorry, 1977. 1977, I believe, is when that was brought in. And that gave him the emergent and that's really what's governing him today. There was an act that was passed in 1930, another one was passed in 1960s, another one passed in 1970s and 1977, the IEEPA, each of which were designed to play in various different types of scenarios. And the one that Trump is referencing in his EO is the IEEPA of 1977. Now, today, the Supreme Court has come out and said that they are interested in reviewing his executive orders and doing so on an expedited basis, which is a little bit scary if you're Donald Trump. I missed a rant that came in earlier. Hands One Pack says, Joe, stop showing us your driving skills and why your wife drives you around. I get it. I get it. So, by the way, the votes came in. It was like 82% saying yes, 13% saying mixed, and only 4% saying no, they don't like the tariffs. And I'm telling you right now, I would have voted yes. I like the tariffs. I want these tariffs here. But I am going to question whether or not, and I have grave concerns as to whether or not all of his EOs are valid. And I think we're going to see that some feel more valid than others. Some might feel more valid than others. All right. SCOTUS blog brought this down today. Supreme Court agrees to decide the fate of Trump's tariffs, setting the stage for a major ruling on presidential power. The Supreme Court on Tuesday agreed to decide whether a 1977 federal law giving the president certain emergency powers allowed President Donald Trump to levy tariffs on nearly all goods imported into the U.S. through a series of executive orders. In a brief order issued by the court's Public Information Office on Tuesday afternoon, the court announced that it granted review in two cases. You have Learning Resources v. Trump, in which two small businesses had asked the justices to weigh in on Trump's power to impose tariffs without waiting for a federal appeals court to rule on the Trump administration's appeal. And Trump v. VOS elections, in which the Trump administration had asked the court to review a ruling by a different federal appeals court striking down the tariffs. The court will fast track the two cases, which will be argued together and hold oral arguments in early November. In a series of executive orders, Trump imposed tariffs that fall into two categories, which collectively cover a wide range of products and U.S. trading partners. First category, known as the trafficking tariffs, apply to goods from Canada, China, and Mexico, which in Trump's view have not done enough to halt the flow of fentanyl into the United States. The second category, known as the reciprocal tariffs, impose a minimum tariff of 10%, which can escalate up to 50% on products in virtually all countries. It's very difficult for us to know exactly how much money we've raised so far through these tariffs, but the estimates are that collectively across the world, it's been well in excess of $100 billion. So just from China alone, they say in June alone, we collected roughly $27 billion worth of tariffs. Now, China is probably the biggest, would be the biggest boatload of cash that tariffs would generate from any country in the world in a given month. But still, if you have, that's just June. You have July, August, September. We're very clearly well over $100 billion that we've raised in tariffs already. So, and the estimates are that on an annual basis, it would be several hundred billion. We could reach half a trillion, if not a great deal more than that. The second category, known as reciprocal tariffs, impose a minimum of 10%, up to 50%. The law at the center of the case is the International Emergency Economic Powers Act, a 1977 law that allows the president to take action to deal with unusual and extraordinary threat, which has its source in whole or substantial part outside the United States to national security, foreign policy. Let's pull up the IEEPA, the International Emergency Powers Act. This was the basis that Trump relied on to say, I have the right to impose tariffs. I know what the Constitution says. I know the Constitution gave that authority, gave that power to Congress. I get it. But then Congress gave that power to me. They gave it to my position as president all the way back when Carter was here. So if you look at the International Emergency Economic Powers, Chapter 35 here, it says, unusual and extraordinary threat, the declaration of a national emergency, exercise of presidential authorities. Any authority granted to the president by Section 1702 of this title may be exercised to deal with any unusual and extraordinary threat. I'm highlighting this language right here because I think that this could potentially be very important language. In fact, let me pull it up over here. Let's do this here. I think that this could theoretically, I think that this language right here is potentially a very, very critical language. Mm-hmm. Because when they say here that it's got to be unusual and extraordinary, I think that is language which is likely to be very important. It's got to be unusual and extraordinary. Because even right out of the gate, as soon as we start looking at this, unusual and extraordinary, it's very easy to see how our current situation with the border crossings is unusual. That's not something that happens all the time. That's something that's never happened before the Biden administration managed to have power. So, and it has to have its source in whole or in substantial part outside of the United States. So I would say certainly that this is outside of the United States, right? We have this fentanyl coming in. We have these transnational cartels who are bringing fentanyl in here. We have the mass migration. All of this is in substantial part outside the United States, the national security, foreign policy, or economy of the United States. And this is potentially a saving grace for Trump. Because on the one hand, it's not simply something that he's supposed to invoke if it's affecting the national security. that all of a sudden there's some invading army that he's able to use these weapons that Congress is about to give him. But even if it's something that has to do with something relatively smaller, or not threatening our physical health but our economic health, it's hurting the economy of the United States, the president declares a national emergency with respect to such threats. So if he declares a national emergency with respect to the economy, potentially that would open up his powers that are being enumerated over here. The problem that Trump is going to have potentially from the Supreme Court, again, is it's got to be something that's unusual and extraordinary in order for this IEEPA to actually, International Emergency Economic Powers Act, in order for that to kick in. It's nice that he declares a national emergency. He has to do that. But it may be exercised to deal with unusual and extraordinary threat. What if it's not an unusual and extraordinary threat? How do you define what unusual and extraordinary threat means? How would the court define that? And I can very easily see the justices coming in and say, unusual and extraordinary threat, mass migration, fentanyl, that's pretty unusual and extraordinary, seeing in the numbers that we've been seeing it. But our economic disadvantage with regard to the rest of the world, is that unusual and extraordinary? Is that something that we haven't been dealing with for decades? We have a trade deficit. I'll remind you that what he said here is his basis for why he wanted to do this. Why is he saying this? He's basically saying that large and persistent annual U.S. good trade deficits led to a hollowing out of our manufacturing base. Okay, is that something that's brand new? Is that something we haven't had for the last 20, 30, 40 years? I don't know. He's using that to invoke his authority under the International Emergency Economic Powers Act of 1977. Look, I want to give President Trump the benefit of the doubt in any possible scenario, but especially when he's effectuating a policy that I agree with. But that does not mean that he has the legal authority to do this. So we need to start with understanding that the only basis for him to have the power to tariff under the Constitution is via Congress giving him that power, because the Constitution would give it just to Congress, and presumably, and you could say that this has been recognized historically, that it's been a valid transfer and delegation by Congress, meaning that there have been previous acts which have been litigated, multiple times, where Congress has delegated that authority. Frankly, as a constitutionalist, I would ask, do they even have the authority to delegate that power? And you could make that argument that they don't have the authority to delegate that power. But I think if you try making that argument that, hey, the right to tariff is exclusively Congress, you don't have the right to delegate that anymore. The president has the right to delegate who's gonna be the final signer on a bill that comes before him. He can't delegate that to the vice president. He has to do that himself. He can't say, I can't make up my mind. You decide, Vance. That's not something he could delegate. So you might say maybe Congress can't delegate the right to tariff, and that's their exclusive domain. Well, and while a constitutionalist like Rand Paul or Thomas Massie might try to make that claim, that has happened before. And there are numerous scenarios. Nixon did it. This happened throughout the 20th century. Many presidents have levied tariffs while invoking statutes that have been effectuated by Congress, where they ceded that authority, delegated that authority to tariff to the president, and no court has ever said they don't have the right to delegate. So clearly, the historical legal precedent says Congress does have the right to delegate. These statutes are valid, even though someone who's a strict constitutionalist might say they cannot do it. The Supreme Court has historically said they can delegate it. Okay, so now we can say that based on that, the IEEPA is a valid statute. It validly gives these powers to the President of the United States. In fact, there have been broader powers. Before the IEEPA, there was a previous act which gave even broader tariff powers to the president, which was upheld as being constitutional. The purpose of the IEEPA was to actually dial it back somewhat. And we're going to look a little bit about into the history of this. So, as we go further in examining this, so the point is, they have successfully delegated it in certain scenarios. The question is, are we living through that scenario now? And who has the right to decide whether or not we are in that scenario? And I think that it's fair, once you accept Marbury v. Madison as being good law, which certainly seems as if that's not going to change anytime in your lifetime or my grandkids, that the Supreme Court has the authority to interpret these statutes. And when it comes to this specific statute, and we're looking at whether this is an unusual, extraordinary threat, is this judicial call or is that the president's call as to whether or not it's an unusual, extraordinary threat? And if it's the president's call, you might ask yourself, does this, and the reason why I think the court is unlikely to leave this as the president's call. And I do think, in my honest opinion here, I don't think that the Supreme Court is going to say, well, that's the president's call if this is an unusual, extraordinary threat. And the reason they wouldn't is for the very reason that the lower courts have been reluctant to do that, which is basically they say, then you're just giving him the power to tariff in any scenario. If you don't need to have an objective, unusual, and extraordinary threat, but we can rely on the subjective position of the president that, well, this situation is unusual and extraordinary, then he has all the tariff power in the world. Because he'll just say, well, this is unusual and extraordinary. It's like, well, what happened? Well, are you kidding me? 4 birds flew past my window. I think they came from Africa. So that's an international threat. He can make up whatever he wants. If you're going to leave it to his exclusive subjective opinion as to whether the scenario is unusual and extraordinary, and when you're trying to assess fairly, properly assess the law, you have to imagine that this action is being taken by a president you detest. And it's easy to do this now. Imagine if Biden had passed these EOs. How would you feel about these EOs? Because you likely wouldn't have much confidence in them being at all. You would think he's going to ruin his soul. So you sort of have to ask yourself, would you be saying that he has the authority to decide what's unusual and extraordinary? I think you'd probably say, you kidding me? That raving dementia patient has subjective opinion as to whether or not our current circumstances are unusual and extraordinary. That doesn't seem to make any sense to me. Well, similarly, once you're going to say that it's not an exclusive domain of President Biden, you have to, if you're going to look at the law fairly, if you're going to assess a situation fairly, you have to say, well, then that's not the president's exclusive call, which means it's not President Trump's exclusive call, which means that now we're looking at the court as to whether or not this is a fair use of what's considered unusual and extraordinary. Now, I do think that deference should be given to the President of the United States, but it has to be something that is justifiably labeled unusual and extraordinary. And it's not either or. It's got to be both unusual and extraordinary. So that's what this statute very clearly says. Now, the specific statute that will go forward, because this is not the only potential hangup that Trump has or the ways that he's going to be attacked. And we know how he's going to be attacked because we can see what the courts have done with his EOs until now. And we're going to be looking at that momentarily. But what he specifically referenced was 1702B, which is that at the times and to the extent specified in section 1701, so whenever you have this situation of an unusual, you have, what are the factors? You have unusual and extraordinary. Why do I have this one? I want this one. You have unusual and extraordinary. This is one factor. You have to have a source which is from outside of the United States, and it's got to be affecting our national security or the foreign policy or economy. Well, I think it's coming from outside the United States. and I think that it's affecting our economy. So those two he's fine on. The question is whether he's going to satisfy this first check mark over here of being unusual and extraordinary. But then the question is, what are they actually ceding to him? And this is another area that we're going to see that the court has really developed a hang up on, not the Supreme Court. In fact, it's not a court that I think you likely have ever heard of before. We're going to be looking at a decision from the Federal Court of Appeals, which you might be saying, what the hell is that? And if you're not saying that, I'd say, wow, you knew better than I did, because that's not something I've ever read a decision from before. But we're going to be looking not at their entire decision tonight, but a little bit of their recent decision, which led to the Supreme Court granting cert. So what he said, what it says under the IEEPA is that once you have these three factors, unusual and extraordinary circumstance from outside the United States that's creating either A, B, or C, a threat to national security, or foreign policy, or economy, in that case, the president may, under such regulations as he may prescribe by means or instructions, licenses, or otherwise, he can do anything under A, but that's not what he invoked. He invoked B. So in those circumstances, he may investigate, he may block during the pendency investigation, he may regulate, and this is the key term that he's focusing on, that he's allowed to regulate, direct and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing in of, exercising any right, power, or privilege with respect to, or transactions involving any property in which any foreign country or national thereof has any interest. I know this all sounds like gobbledygook to most of you, but I'll ask you to focus on when we're reading through these paragraphs is ask yourself if it says expressly here tariff, impose tariffs. And you can look through this paragraph pretty clearly from today until it comes before the Supreme Court. You're not going to find the word tariff in this paragraph. Nowhere here does it expressly use the word tariff or tax. Duties, none of that. What it specifically says is regulate. And that's really the key word here, that he can regulate. Now, Trump and his administration want to say that regulate includes imposed tariffs. Now, it either means imposed tariffs or it doesn't. If this does not mean imposed tariffs, if there's nothing here, if this entire thing is a big fat fail as far as giving him license to impose tariffs, the bottom line is he loses on these tariffs. All of these tariffs, none of these tariffs are any good. If that's what the court if that's how the court reads this, unless they agree with Trump that regulate implies that he has the right to impose tariffs, his tariffs don't work. They're just unconstitutional. That's just the reality. Because again, this is the statute. The default is that Congress alone has the power to tariff. There are exceptions in certain circumstances because Congress has passed statutes which say in these various scenarios, the president has the authority to tariff or the authority to take these actions. In certain scenarios, he has the authority to take these actions, and Trump wants to read these actions as including the power to tariff because of this word regulate. That's the key word that he's fixating on. Maybe direct. But it does not say the word here. It does not say the phrase here expressly. And the lower courts have basically really fixated on this. You can say, oh, come on, that's being ticky-tacky. That's what it clearly has to mean. How is he regulating if he's not doing it? If he's not able to tariff? And I'll answer that question. There's a lot of ways he could regulate. He could say, I'm not going to let we're not going to let any Americans import lumber from this country. That'd be regulating it. That's different from imposing tariffs on it. Now, you can make a counter argument philosophically and say, well, if you can stop it from coming in, then you can charge them for allowing it to come in. You say, I'm not letting it come in unless you pay a certain amount of money. And I think that that's a logical argument to make. The question is whether it's going to be recognized as a legally viable argument to make. Certainly could restrict how much of a certain product come in. That would be under his authority. But that's what we're going to be focusing on here as to whether or not these are any good. So the two key things that Trump is going to be fighting over and needs to win on both of them in order to uphold one or all of these tariffs are these two factors. Are we in an unusual and extraordinary threat? And does this paragraph give license to a president to impose tariffs? That's the key. Whether 1702B gives the president the authority to impose tariffs. So are we in a situation that this act kicks in under 1701 little a? Then under 1702 capital B, does that authorize him to impose tariffs? I'm trying to make this as simple as possible so that anyone who's got no legal background at all can understand what the root of this argument is. So now you can understand, once you understand the structure that we're dealing with, then you can start to digest the arguments that are being made by both sides and understand it in a lot more comprehensive level. Now you're like, oh, okay, these are the two key points that they're fighting over. So with that in mind, we can look at the decision of the United States Court of Appeals for the Federal Circuit, which issued a decision on August 29th, just 10 days ago or thereabouts. And in that decision, there's actually multiple decisions that are in here because they're dealing with multiple cases. But Trump was pretty much getting beaten here. I'll tell you right now, he's struggling here with the court because they don't agree with his reading of the IEEPA. The government appeals decision of the Court of International Trade. So this is a whole different court system than we're used to. This is not something where you're dealing with the Southern District of Florida or New York or the District of Columbia, the court from the District of Columbia, or the Second Circuit or the Ninth Circuit. This is not anything like that. Because this is dealing with international trade, it starts with a specific court that's called and designated specifically for this Court of International Trade. And the appellate, you appeal from there to this court, which is the, I'm going to get the precise name, United States Court of Appeals for the Federal Circuit. It's not even called a circuit court. And they're right below the Supreme Court. You learn something new, right? So the government appeals decision of the Court of International Trade setting aside 5 executive orders that impose tariffs of unlimited duration on nearly all goods from nearly every country in the world, holding that the tariffs were not authorized by the IEEPA. Because we agree that the IEEPA's grant of presidential authority to regulate imports does not authorize the tariffs imposed by the executive orders. And that's telling you what we were just saying now, that second argument. That we're saying, hey, you don't have the authority here. So they're saying because when that word regulates that comes up in 1702B doesn't authorize tariffs imposed by executive orders, we affirm. And we affirm the lower court, which says Trump doesn't have the authority to impose these tariffs. This case involves the extent of the president's authority under IEEPA to regulate importation in response to a national emergency declared by the president. Now, again, this argument about regulating is more lethal to Trump than the first argument. Remember, we said there's 2 arguments here. One is who decides whether or not this is an unusual and extraordinary circumstance to let this whole thing kick in, to let this to say, are we even here? Are we dealing with this? Are we here? So when we're deciding, are we here? I'll let you try writing with a are we here? Are we there yet? Are we there yet? You try writing with a mouse. So this first one, if he loses here with the "Are we there yet?" issue on 1701A, there you have to look at each tariff and say, is this an emergency? Is this one an emergency? Is that an emergency? Is this an unusual extraordinary circumstance? And you might reach different conclusions depending on which scenario we're talking about. So even if he loses on one tariff, the other tariffs might still be okay. But if in fact it's not about are we there yet, but under 1702B, does he ever have the power to tariff? Even if we get there and the court decides no, he doesn't, then all of the tariffs get blown up. None of them are any good. And that's what the court is basically saying here in their opening paragraph, that we think that this authority to regulate doesn't give that power to the president. And they walk through why they say no. This case involves the extent of the president's authority under IEEPA to regulate importation in response to a national emergency declared by the president. For many years, Congress has carefully constructed tariff schedules, which provide for in great detail the tariffs to be imposed on particular goods. Since taking office, Trump has declared several national emergencies. In response to these declared emergencies, the president departed from the established tariff schedules and imposed varying tariffs of unlimited duration on imports of nearly all goods from nearly every country with which the United States conducts trade. This appeal concerns 5 executive orders imposing duties on foreign trading partners to address these emergencies. And they reference the executive orders, as I said, 5 different orders, which are all designed to shift and adjust our normal tariff schedule. We summarize the history of the challenge executive orders by first discussing the national emergencies in response to which they were issued and addressing the nature of the measures. So first we have January 20th, President declared the existence of a national emergency with Mexico. That was the first one. And that was all about the cartels and the criminal gangs and et cetera, et cetera. Literally the day he came into office, he identified the problem coming out of Mexico. The day he sworn in, before he laid his head on the pillow, was imposing duties to address the situation on our southern border. The president also expanded the scope of national emergency declared in Proclamation 10886 to include threats originating from Canada and the People's Republic of China. On February 1st, 2025, he declared that the sustained influx of illicit opioids and other drugs has profound consequences on our nation and stated that Canada has played a central role in these challenges. So again, when it comes to Mexico and Canada and China, so there, the problem that he's identifying, I think, more easily squares away with being definable as unusual and extraordinary. And that's why I'll tell you right now, if you're almost an hour in with me, I'm going to tell you right now, I think he has a decent shot on winning with respect to those tariffs. I don't know why. I don't know why I'm getting a circle here. That's never good. You guys even hear me? Is this thing on?
All right.
All right, I think we're back. Oh, you're too kind. Thank you, Kansas Mima. Thank you so much. All right, so we're back in now. All right. So the president also expanded the scope of the national emergency declared in 1086. And now he basically brought Canada and China into this national emergency that's happening on our border and with respect to the drug trafficking problem that we have. And that was the second order. He similarly stated that this emergency had been exacerbated by China's failure to arrest, seize, detain, or otherwise intercept chemical precursor suppliers, money launderers, and other people. So he found a way to tie China into this problem also. In response, he gave them trafficking tariffs of 25% ad valorem and said, screw you. In each of these executive orders, the president stated that the circumstances constituted an unusual and extraordinary threat which had its source in substantial part outside the United States to the national security, foreign policy, and economy. And that's why we're in this IEEPA situation. And imposing tariffs, he relied on that A1B of the IEEPA and specifically found the action under other authority to impose tariffs was inadequate to address this unusual and extraordinary threat. So that's where he went. That's where he said his source of authority is to impose tariffs. The president subsequently modified the trafficking tariffs, first after determining that China had not taken adequate steps to alleviate the illicit drug alleviate the illicit drug crisis, and that the situation had not abated. So he increased it on Chinese products from 10% to 20%. The president further implemented duty-free de minimis treatment for other covered articles in Canada and Mexico, and said, we're punishing you for that. On April 2nd, the president imposed what this opinion refers to as the reciprocal tariffs. This is now when he started making global tariffs to everyone, right? That was in April. So he said the baseline of 10% ad valorem duties on imports from nearly every country, nearly every single country having to pay these tariffs. If anyone that had any significant trade relationship with additional ad valorem duties ranging from 11% to as high as 50% to be imposed shortly thereafter on a per-country basis. Remember, he even had that whole cool chart there, which was awesome. In imposing the reciprocal tariffs, the president again invoked his claim authority under IEEPA, the NEA, Section 604 of the Trade Act of 1974. He explained the reciprocal tariffs addressed an unusual and extraordinary threats to national security and economy of the United States posed by underlying conditions, including a lack of reciprocity in our bilateral trade relationships, disparate tariff rates, and non-tariff barriers, and U.S. trading partners' economic policies suppressing our domestic wages, saying that because we don't have because they're able to get their labor much cheaper, they're basically screwing us over. President suspend the imposition of additional country ad valorem duties for all countries except China until July 9th. Repeatedly amended the China-specific reciprocal tariff rate in response to China's adjustments when he was haggling with them. This is one of the awesome things about the tariffs is it gave him a lot of leverage to basically try punishing China. If anything, and this is one thing I want to point out, one of the things that Trump really did a great job of proving with the way he handled these tariffs to anyone who's assessing him fairly is that his ability to impose tariffs has given him a great deal of leverage in haggling with these other countries to the benefit of America. His unique ability to actually go out there and say, you work with me or I'm going to slap a heavy tariff on you has benefited Americans. It's almost impossible to deny otherwise. This is why I referred to the title of the show is Will SCOTUS Ruin the Economy? Because ultimately, if we handcuff him from being able to do this, I do think we're hurting the economy. We're hurting Americans in general. I think it would be a terrible loss for us. I think that Congress should specifically grant him that authority, or at the very least, say, look, we already have our tariff schedule in there. We're going to allow the president to fluctuate our existing tariff schedule for the next year. And basically grant him that latitude so that everyone in the world knows that when they're dealing with Trump, that he does have the ultimate authority and not that he's got to go back to mommy and daddy and 400 screaming idiots in Congress to say, to haggle over what tariff levels we're going to have. But it's well known, well documented, and easily understood by all of our peers in the international community that if you're going to be negotiating with Trump, it's totally up to him as to what their tariff level is. That is a very, very healthy thing for this country. And the fact that folks like Thomas Massie and Rand Paul cannot see that makes me question whether they're idiots or so blinded by their need to have recognition and authority and power and jurisdiction that they basically don't give that they let that take priority over bettering the lives of Americans. It's very, very aggravating. Because I don't think that like many people on the left, they're all about their own acclaim. But I think that much as I will frequently refer to liberals as being so open-minded that their brains have fallen out, I think that under the rubric of being like they're all about the Constitution, that they sort of use that as a basis to sort of ignore what they're actually doing here and disregard that there is constitutional authority in some regards to what Congress has already ceded to the president. So it's frustrating. It's very, very frustrating because we all want to see America do better. And I actually think Thomas Massie and Trump and Rand Paul fit into that category. And yet I think that they seem to be seeking to entrench themselves as being as being men of principles, disregarding altogether pragmatism in ways that seem almost unrealistic. Let me cover a couple of rants for a moment. Hans one says, declaration of national emergency is a political issue. If Congress want to override, they establish other laws that grant them power to do so. Okay, that's true. Zelly and Joe, I put a message in locals for you. Did you? Let me check out what we got in locals. Ooh. That's funny. It's very not true. Very, very not true. But thanks, Johnny. Zealand says, cult leader logic, the squirrel sacrifice, what does this say? Was made tonight along with the grape Kool-Aid. This is a layman's thought on it. Trade policy negotiator is also under the State Department duties, with the State Department being on the executive branch and Trump being the head executive branch. He has full right to do them as part of trade negotiations. I would agree with you that philosophically, I disagree with what our founding fathers did. Meaning, I love the Constitution. I think what they put in the Constitution with respect to controlling the ability to tariff others, that if I was sitting there in the First Continental Congress, I was sitting there with the drafters, I would have said, that's really the president's leverage. Why are we going to strip that from him? To me, it's a poorly thought out element to this whole to the Constitution. But that being said, you can't pick and choose what parts of the Constitution you like. You either go with it or you don't. So I can understand the argument that, the Constitution says what the Constitution says. However, since there are exceptions to the Constitution with regard to this thing, and this is a particularly sus part of the Constitution, I wouldn't disregard it, but I would be more open towards leaning into the exceptions. Right? I mean, I think that makes sense. I'm just saying, if I were a founding father, that's the argument. I would be screaming at Madison, saying, and Hamilton, I'd be screaming at Hamilton. Wait. So when they're going and negotiating, they have to come back to Congress? Does that make sense? I would amend the Constitution on that. That's what I'd be screaming for. They should amend the Constitution. I'd amend that. All right, getting back to this decision, we're going to go a little bit further into this. A little bit further, even though I think you all see where it's going because you're smart enough to read the writing on the wall. So they're going on and on through the history as to what happened with the tariffs and different bases. And then saying how on July 7th, so we're at the stage where he had implemented the reciprocal tariffs and just started giving them across the board to everyone. And then saying how on July 7th, he paused enforcement of reciprocal tariffs until August 1. And then they all started kicking in. On April 14th, 5 small businesses came in and started complaining about this, saying that he doesn't have the power to do this, doesn't have authority. And they brought suit before the CIT, the Court of International Trade, against the United States and various government officials in their official capacities, challenging his imposition of both the reciprocal tariffs and the trafficking tariffs. On May 28th, a three-judge panel of CIT granted summary judgment to the private plaintiffs and state plaintiffs in a consolidated order, holding that both tariffs, reciprocal and trafficking, were beyond the president's authority under the IEEPA and permanently enjoining the government from imposing them. The government appealed both cases the same day and moved to stay the injunction pending the appeal. So this is being I keep forgetting the name, United States Court of Appeals for the Federal Circuit, we decided, okay, we're fine with that, and imposed what in this opinion for. So we came in there and we basically said, okay, fine. Let's take a look at this. Let's take a look at this case. Sorry, I lost my place there. And consolidated the appeals. Before we reach the merits of the case, we briefly discussed the history and legal authority concerning the imposition of tariffs as relevant to this appeal. And I thought this was really interesting from a historical perspective. So if you'll indulge me, we're going to run quickly through what happened historically. So let's start with this. Congress says that the power to lay and collect taxes, duties, and duties is really the key word here, right? Because taxes really is referring to taxing Americans. Duties is on imports. And to regulate commerce, that tariffs are a tax. I don't agree with that. The framers' Constitution expressly contemplated the exclusive grant of taxing power to the legislative branch, when Patrick Henry expressed concern that the president may easily become a king. So that's why they were afraid of that. That's why they would have been. That's what they would have been yelling back at me. They said the power of the purse is in the hands of the representatives of the people. At the time of the founding, and for the most of the earlier history of the United States, tariffs were the primary source of revenue for the federal government. So that's a big difference from what's going on now. They didn't have income tax back then. There was no such thing as federal income tax. So that's why they wanted the power purse to be in the hands of Congress. In that sense, it makes a lot more sense. If you look at it from the historical context, it makes a lot more sense why when you don't have federal income tax, you don't have the sales taxes, you don't have all these different taxes that we have today, you can understand why they put tariffs and the power of the purse in the hands of the government. But they are not the primary source of revenue for the government today. We must a long time setting tariff policy was thus considered a core congressional function. And back then, I guess it made a lot more sense. In 1913, the 16th Amendment was ratified, granting Congress the power to lay and collect taxes on incomes from whatever source derived. This ability of Congress to impose a domestic income tax reduced the importance of tariffs as a source of revenue. For much of the early history, Congress set tariffs without authorizing the president to adjust tariff rates by entering into international agreements. In the late 19th and early 20th centuries, Congress began to delegate to the executive limited authority to activate or suspend tariff rates through international agreement. For example, in the Tariff Act of 1930, Congress set forth tariff rates in 95 pages of schedules. Through the Tariff Classification Act of 1962, Congress adopted the tariff schedules of the United States. What is that called? the HTSUS. What is that? The HTSUS was enacted by Congress. And that sets the United States' current tariff schedules. During the entire period, Congress authorized the president to enter into agreements reducing tariff rates, or in some cases, increasing tariff rates. That presidential authority to increase rates was cabined, meaning it was limited to certain scenarios in various respects, including limitation of the president's authority to increase rates by more than a certain percentage of the established statutory rate. So he had no authority to basically jack up tariffs. He might be able to tweak them, but not to jack them up. The HTSUS rates reflect applicable governing tariffs that have been set over time, in part through international negotiations and multilateral and bilateral agreements. In 1916, Congress passed legislation that created the U.S. Tariff Commission, which was later renamed the U.S. International Trade Commission, and that the ITC's responsibility is to provide recommendations to the president in making adjustments. The framework for the schedule set forth in the HTSUS is implementation of the 1983 International Convention of Harmonized Commodity. All right, that's getting a little bit bogged down at this point. Congress's enactment of the HTSUS provide that its terms, including each modification or change by the president under authority of law, shall be considered to be statutory provisions of law for all purposes. So now he's basically being given the gift of power of controlling tariffs under that. To the extent that it provides, it gives him the leeway on moving tariffs. In 1917, Congress enacted the Trading with the Enemy Act. That was the one I couldn't remember. That was to address threats to the U.S. economy resulting from our entry into World War I. So now you have Woodrow Wilson in the White House, and they wanted to give him authority to deal with World War I, so they passed the TWEA. And that empowered the president to investigate, regulate, or prohibit any transactions in foreign exchange during wartime. In 1933, Congress expanded the TWEA by authorizing the president to deploy the power to investigate, regulate, or prohibit foreign transactions during other national emergencies besides war. In 1941, just 1 week after Pearl Harbor, Congress further broadened presidential authority under TWE. What's this? Trading with the enemy? By adding the phrase importation and exportation to the list of transactions involving foreign property that the president may investigate, regulate, or prohibit. After World War II, presidents used this Trading with Enemies Act to impose economic sanctions on foreign adversaries, regulate foreign exchange, and control exports based on several declarations of national emergencies. So we've seen different presidents do this. President Truman invoked TWA to declare a national emergency with respect to the Korean War. I think this is really interesting. I think it's really interesting to see how different presidents have used this power. And it is reflective of how the court may respect or not respect Trump's use of the tariff power. And this is all, by the way, this is a finding that was made by the Appellate Court for the Court of Appeals for the Federal Circuit. So this is something that, this is purportedly, in no way biased. This is just giving us a factual look at how the law, how presidents have used this and how the law has regarded this and what steps Congress has taken, which is why I think that this is very informative and likely to be a primary, likely to, no, we shouldn't call it primary source, but likely to be a source that the Supreme Court and their little Yale law students who are clerking for them are going to be looking at to review the history to the extent that they think the historical context of the ability to tariff is an important factor in assessing Trump's current abilities. Executive Order 11387 governing certain capital transfers. President Johnson placing controls on capital exports in 1968. In 1971, we saw Nixon asserting the authority of temporarily suspending existing tariff agreements that reduced the statutory rate so as to impose a temporary additional 10% ad valorem duty, which was not to exceed the amount set in the congressionally approved tariff schedules in the United States on all dutiable articles. So Nixon used it, Johnson used it, we saw Truman used it. President Nixon's proclamation and saw a refund of taxes paid, but they weren't using this particular statute that Trump is trying to use now, and that's going to be a critical factor here. The United States Customs Courts ruled in favor of Yoshida. Now, Yoshida case is something that they spend a great deal of time fixating on. So Yoshida International, a zipper importer subject to the surcharge, filed a lawsuit challenging the legality of the temporary tariff surcharge imposed by Nixon. And he wanted a refund on the taxes paid. The U.S. Customs Court ruled in favor of Yoshida, holding that the president had exceeded his statutory authority as delegated by the Tariff Act of 1930, the Trade Expansion Act of 1962, and Section 5B of the TWEA in assessing the surcharge. So Yoshida sued Nixon and won, and accordingly concluded that Nixon's imposition of temporary surcharge was not authorized. While Yoshida won, because it ends up being a Yoshida 2 as well, was pending appeal, Congress enacted the Trade Act of 1974 and codified as amended 19 U.S.C. 2101 to 2497B. Section 122 of the Act, the Trade Act, gave the president the authority to impose for up to 150 days import quotas or other temporary import surcharge of up to 15%. So they capped him at 15% to deal with large and serious United States balance of payments deficits. So they said, you got a deficit, you can go up to 15%. To prevent an imminent significant depreciation of the dollar in foreign exchange markets or to cooperate with other countries. The next year, our predecessor court, the Court of Customs and Patent Appeals, reversed the Customs Court decision and upheld Nixon's 10% surcharge, determining that its imposition fell within his authority. So he now won. Now President Nixon won. Yoshida, and they're referring to Yoshida 2 at 566. The court also noted that a surcharge imposed after January 3rd, 1975 must, of course, comply with Section 122 of the Trade Act. As described in greater detail below, the decision does not hold that TWA create unlimited authority in the president to revise tariff schedule, but only the limited temporary authority to impose tariffs that would not exceed congressionally approved tariff rates. So they're going to say, look, even though Nixon won there, the reality is he still was, what did he do? There had been approved congressional rates. Those approvals had been, those rates were reduced because the tariffs were suspended. He punished certain countries by lifting the suspension and putting the original congressional powers on, and that's where the court approved it. But it still ultimately had congressional backing, that Congress had originally set these tariff schedules up themselves, and he was just putting them back into effect. That's where Nixon had the power. That's very different than Nixon going and writing his own numbers for the first time, the way Trump is doing. That's where the court is going here very clearly. In 1976, Congress pared back the scope of TWEA and enacted the National Emergencies Act, the NEA. The NEA limited presidential power and placed restrictions on the use of authorities granted by TWEA. As relevant to this appeal, the NEA ended within 2 years. All powers and authorities possessed by the president as a result of the existence of any declaration of national emergency. So they say you can't have a national emergency that's going on for more than 2 years. As a result of the existence of any declaration in effect on September 14, 1976, and placed new restrictions on declaration termination of the future national emergencies. The NEA did not explicitly address Section 5B of the TWEA. However, the legislative history indicates Congress's intent to study Section 5B of TWA and propose such revisions as might be found necessary to limit the president's exercise of authority. The IEEPA is a result of this legislative effort and is consistent with Congress's stated goal to revise and delimit the president's authority to regulate international economic transactions during wars or national emergencies. So the point that the reason the court gave this entire background, which was, to me at least, very interesting to see how different presidents have tried using tariffs and have been limited by Congress in their ability to tariff throughout primarily the last century. And basically trying to explain how they're now reading the IEEPA in its historical context, that it was designed to restrict the president more than presidents had been restricted in the 30s, 40s, 50s, 60s, and early 70s. That's what the whole point of the IEEPA was. And they say Congress adopted the same list of authorities as TWA, including the power to regulate importation, but Congress expressly limited the president's authority by substituting authorities which were both more limited in scope than those of the TWA and subject to various procedural limitations. The House report also mentioned that Yoshida II decision's background came into play. So they weren't very happy with the fact that the court ultimately approved Nixon's work. They really wanted to take back their power to tariff and limit the president's ability to use it. In that case, Section 5B was not among the statutes cited in the presidential proclamation as authority for the surcharge, but was so cited later by the government in response to its suit brought by the Customs Court. The IEEPA provides that after declaring a national emergency pursuant to the NEA, the president may investigate, block during the presidency, regulate, direct and compel, nullify, void, prevent, or prohibit any importation or exportation. That's what he has ability to do. Any property in which a foreign country national thereof has any interest. So that's what he has the right to do. Notably, they do not use the word tariff, do not use the word duty, or any similar terms like customs, taxes, or imposts. The IEEPA also does not have a residual clause granting the president powers beyond which those which are explicitly listed. And they're going to fixate on this because the ability to tariff, the ability to tax is one that we're going to see further in this decision. If it's not express, it doesn't exist. And that's why they're going to say that just because it says regulates, and you might be able to read it in there, that unless Congress is very express in granting the authority to tax, specifically using that word, the power doesn't exist. Now, frankly, to be fair, while I really appreciate Trump's tariffs, I very much appreciate Trump's tariffs. I think that they're beneficial to the United States. And I think that that Congress should authorize him to use this. I cannot sit here and pretend that I am not greatly appreciative of the fact that there must expressly be the word tariff, tax, something to that effect, before we give any governmental authority, body, anything, the ability to tax and tariff us. Tax us, tariff others. That this ability to tax and tariff, which frankly, 16th Amendment was disgusting in basically imposing federal taxes, was a terrible thing. So I'm in this very, very weird position now, where if you look through this decision and when you go through this decision, they basically start saying that they don't interpret regulate as meaning tax. And you're going to see that if we look further in this decision, I think around page 43 or so, they basically say if it's not express, if it doesn't say specifically tax, tariff, it doesn't exist. The government's expansive interpretation of regulate is not supported by the plain text. The government's reliance on the ratification of a predecessor court of Yoshida II doesn't overcome the plain meaning, and the government's understanding of the scope of authority granted by the IEEPA would render it an unconstitutional delegation. That they don't have the authority to delegate that out. We started by addressing the statutory text, but And once he declares that emergency, these are the different powers that he has. But read through it, bucko, and you're not going to see anywhere that he has that. And you're saying the government wants to locate the president's authority, purported authority to tariff based on the word regulate, but the plain meaning of regulate does not support the government's argument. Regulate means to fix, establish, or control, to adjust by rule, method, or establish mode, direct by rule or restriction. Regulate also means to govern or direct according to rule. The plain meaning of regulate does not include raising revenue. The government is forced to rely on a syllogism. It contends that regulate importation means adjust or control the quantity of imports, and tariffs are a way to adjust or control them. And that's technically true. But the government's interpretation of regulate would require regulate to have multiple meanings in the very provision which the government relies. The Supreme Court has never engaged in such interpretive contortion to conclude that Congress intended to give the same word in the same statutory provision different meanings in different factual contexts. It is a very expansive interpretation of the word regulate. So I find myself personally in a very difficult situation here, where I really want him to have the power to tariff. I think the tariffs are great, but I really don't like the idea of the power of the president being allowed to tax us. I do not, while I understand that tariffs, a certain percentage of tariffs, ultimately maybe is likely to be passed on to we, the American consumer. And a lot of people want to pretend that a 50% tariff on China translates into a 50% tariff on us, which is crap BS. And if you think through the economics of it, is obviously stupid. But there is some sort of residual effect as far as our goods costing us more. They're not going to go up by 50%. But, I can't deny that a 50% tariff is likely to increase the price of a good by at least 2%, 3%, 5%. Now, that good might be just a tiny component in a much bigger thing. So, yeah, will tariffs ultimately probably cost us some money? I think you're lying to yourself. It's going to cost, if you claim it's going to cost you $0. So there's definitely some sort of taxing effect that it has on Americans. And I do wish that he had that power, because I think that ultimately that taxing effect on our dollars would be to our economic benefit, because this is a way that he's strengthening the dollar in other ways, where ultimately we would have a very strong net benefit if Trump is allowed to wield these tariffs like they're basically some giant schmeckle that he's waving in another country's face. I think it's a very effective tool that he has, because he's basically using the economic leverage that we as American consumers have. We are the biggest customer of the world. We have more money, we spend more money, we are basically the buying power in the world. The ability for a country to sell to us is an invaluable resource. The same way as a manufacturer is desperate to get his product on the shelves of a Costco or of a Walmart. America is the Walmart of the world. America is the Costco of the world. Anyone who's dealing internationally wants to trade with us, and they're happy to pay for it. So to the extent that we can actually draw their money in for the privilege of working with us, to the extent that he can even use the opportunity to trade in the United States of America for purposes of benefiting our trade or in other ways of dealing with these countries, I say that we should empower our president of the United States to use our collective buying power as a force to benefit America for American first policies. I think that is a wonderful thing, and I love the fact that Trump has been doing that effectively, powerfully, bringing other countries to their knees. I think this has been beneficial to us in ways that only a completely deranged, psychotic, anti-Trump person could fail to see very, very plainly. So someone who's, basically an American masochist who in his heart doesn't really care very much America, they might not appreciate it. But anyone who cares about American interests has to be very pleased with the way Trump has been wielding our power around and our buying power around as if it's his giant schmeckle and rubbing it in the face of every other world leader. It's an amazing thing. So I like him having the authority to do that. And that's one of the reasons I'm a very big fan of his tariffs. Because he's basically walking up to these different countries and just that's what he's doing to them, slapping them around. And what's that hand? That hand is not him threatening to harm them or bomb them. It's just, hey, you want to get in? You want to get in? I hold the key to the door. So bend over and do what I want. I hold the key. And everyone wants to get in. You think Biden would ever do something like that? You think Obama would ever do something like that? You think even Bush would do something like that? No. No, they all rolled over. Oh, okay, we want to be respected and liked by the international community. We now finally have a president who has the cojones to stand up there and say, no, pay me. And by me, he means America. I think it's an amazing thing. So I love him having that authority. I love him having that as a tool at his disposal when he's dealing in international affairs. I think it's an amazing thing, and I think that it's a weapon that in his hands benefits you and me almost as effectively as our nuclear deterrent that we have stored away, the trillions of dollars worth of nuclear deterrents that we have. And in many ways, far superior to that. Because it's less confrontational, less likely to result in actual deaths, and instead just making us all richer. And I resent Congress not enabling him to do this, not empowering him to do this. At the same time, as an attorney, as someone who appreciates our Constitution, as someone who appreciates, what's a healthy course for our country, I like the fact that our judiciary basically says, hey, you're not allowed to tariff unless there's an express written provision saying this person has an authority to levy taxes. I think that's a very healthy thing for us in general. And I think you're crazy if you disagree with that. I think that the position that I have here is frustrating because I want him to have the power to issue these taxes. But I don't want this to be I still don't like obviating a strong rule saying unless it's black and white that a person or body has the power to tax, you have no power to tax. I think that's a wonderful, wonderful thing that I don't want to play around with at all. So I'm frustrated. And I understand that when our founders were basically dealing with this and looking at historical context, the ability to tariff was the power of the purse. But seeing as how it's not the power of the purse anymore, I feel like it's a pettiness by Congress that they don't pass this over to the president in order to enable him to slap around other countries. The situation, as far as our buying power and the economic might of America, was a completely different thing in 1790 compared to what it is in 2020 in 2025. So this is something that I think it should be amended, specifically with tariffs, not any other taxes. I don't want to be able to tax us, but tariffs. I think we need a constitutional amendment. That's what I think we need. But I'll tell you now, if I was sitting on the Supreme Court, if I was sitting there, I'm not sure I would approve these tariffs. I can see these tariffs really being a struggle. Maybe I would find a way to read and regulate to mean tariffs and give him that first one and all those. But the reciprocal tariffs, I don't even understand. I cannot in good conscience tell you that I cannot in good conscience make the intellectual argument in good faith that this tariff over here, the reciprocal tariffs, are properly qualified as something that's an unusual and extraordinary threat, because this is an ongoing threat all the time. This is something that's always there. So tell me it's unusual and extraordinary that we are that we have a trade deficit with a bunch of countries is just I can't in good conscience sign off on that. So unless I would basically say it's always the president's decision, which means that basically he has the power to tariff, and I wouldn't feel comfortable as a sitting member of the bench to basically start saying I would feel like I'm engaging in judicial activism, in judicial legislation, by basically saying I'm hereby giving the power of tariff to the president of the United States, when really that's what Congress has to be doing. And they should be doing it by an amendment. That's what should happen. We should have an amendment that, given the completely changed nature of our society today versus 1790, that element of the ability to tariff is something which is best left in the hands of the president rather than Congress. Congress already has enough power of the purse with respect to our handling the nature of taxes that they charge us Americans. But tariffs, you don't have to give up on the power of tariffs, but they certainly should have the ability. They should have it. It should be an equally shared ability with the president of the United States. If we want to, I think it's a healthier direction for our country. Certainly, when we have a president there who's willing to use our collective buying power as a way to benefit and put forward American first interests. That's my position on this. What will the Supreme Court say? I don't know. But I'll tell you right now, I'll be very surprised if the reciprocal tariffs survive the end of the year. I'll be very surprised at the Supreme Court. I do not think that they're going to let these reciprocal tariffs stand. Maybe they let the southern border tariffs stand with respect to Mexico, Canada, and China to the extent they're still in effect. Maybe. But I do not think that these reciprocal tariffs will stand. I don't think they will. I think the Supreme Court's going to knock it out. And frankly, if I was sitting on the court, I don't know that I would stand behind them, because your role is not to write the laws and pass policies that you like. Your role is to follow what the law says, and under the law, President Trump is standing on very, very shaky ground with respect to these reciprocal tariffs. As much as I love these reciprocal tariffs and wish that he had that power under the law, I have strong concerns about whether or not he actually does. That's how I see it. I don't know how I missed two of these in Patrick Kennedy. I'm so sorry. We need someone to take the sword to the Gordian knot. This is boring law stuff. I'm sorry. Tomorrow, Patrick. When has anyone previously blocked an international trade deal in your lifetime? I don't know. I can't think of any. I'm so sorry that I missed these. You sent these ages ago. I am so sorry, Patrick. I'm going to give you the horn just because I feel guilty. Wake up. Patrick's here. Sorry about that. I feel really guilty. The term regulate ties it to the Commerce Clause. Regulate is the term used to define what Congress can do, illustrating a similar power. It's supposed to be an express reference to taxes. You try writing with a mouse. I drew my scroll icon with a mouse, not a pen mouse, a regular computer mouse in Adobe Illustrator. It's not the mouse. Just stop it. Just stop it. Think about tariffs like a treaty president negotiates, Congress affirms. at the very least. But, you know, they're basically saying he has no authority at all. American shekels are our schmeckel. It's true. It is our schmeckel. It is. Well, American shekels are our schmeckel. We're going to have to go through some pain. How about we look into uplifting our MAGA youngins? What do you want me to do for that? I'm happy to help you with that. Happy to help you with that. I will ask if one of you can confirm whether or not the Ryan Ruth trial is televised. If there's a way for me to live stream it. If there is, I think I'm gonna end up doing it. Aside from the EO, if they void the tariffs, what happens to the agreement he signed with other countries? Are those void too if they include tariffs? See, I don't know. I don't want to weigh in on this because you're asking me this on a law show, especially this episode, which is very law oriented, because I'm not an expert when it comes to international law. And I have questions: what happens when he signs an agreement, and if it's not ratified by Congress? Because treaties are supposed to be ratified, and as far as the nature of what deals he's authority to sign without ratification by Congress, I'm a little bit. I've never looked into that where I can give you an opinion as an attorney on that. So I appreciate that. What the question you're asking is a proper question to ask. I just don't feel as if I have enough background that I feel comfortable weighing in with an answer. You missed my second super chat. Did I really? I got 100% of my parallel parking test when I was 16. I have great spatial sense. I can also tell if something is level and plumb by eyeballing it. Really? Okay, I will tell you this. I have an embarrassing story to share with you. An embarrassing story. I'm going to close with this. I'm going to close with this embarrassing story. I'm going to close with an embarrassing story. When we bought this house, I'm gonna even tell you. I'm gonna hide my head in shame when I'm done with this story. Okay, such a bad story. Such a bad story. Okay. Yeah. Anyway, I will be back here tomorrow. I can't believe I'm gonna tell you this story. Oh my god, this is so bad. This is so humiliating. But you just reminded me of it. Okay. But I will tell you, don't eat lab meat. It's not meant for you. It's meant for they, them. Do not eat the bugs. I'm going to share a story with you, and then we're going to close on out of here. Okay? Share a story, and I'm going to close the show. When I bought this house I'm currently living in, it's a long time ago. Long time ago. And I believe it was around the time that like the second intifada was going on. So there was very hot it was like I felt like tension around like Palestinians. This area was growing as far as the Jewish community here was growing. And when we're buying our house, so we were very, very concerned because I had like a Palestinian, the house, one of my neighbors here was Palestinian. And my wife was very freaked out about it. She was very, very nervous about it. Because like I said, there was just like a lot of tensions that were going on. And we moved into the house. And like one of the things that like I was like, stop freaking out about it. She's like, how do you know? Like maybe like leave a bomb behind. Like, what's to stop them? And I was like, come on, that's ridiculous. That's crazy. We come to the house and we move in. And I open a closet. And there's this case that's there. That's left behind. And I think it was my wife who like called me upstairs. She's like, can you come up here? Can you come up here? There's a case here. I don't know what this is. She's very freaked out. So I open it up. And I see these vials, which like are in like this cushiony type of thing. So you open up this case. It's like this big, the case. And there's these vials which have in the foam there was like sort of built into there these vials of this greenish liquid. And I was like, I don't know what the hell that is. What the hell is? She's like, what is that? What is that? I was like, I don't know. I don't know what that is. She's like, you think it's some sort of toxin? Do you think it's some? I was like, I don't know. I don't. She's like, you think it could blow up? I was like, I don't know. I don't know what that is. I got all my little kids. All my kids at this point in my life are like, my oldest was like 6, 8. I got 4 little ones. And she's like, what should we do? Should we call the police? Should we call? I was like, I don't know. She's like, you want to take it out and move it? I was like, I'm not touching that. Are you kidding me? I'm not putting my hands on that. I don't know what the hell that is. She's like, let's get the family out of the house. We'll just call the police. We'll call the fire department. They'll come in here and they'll just. I was like, I don't know what that is. So that's what we did. We called the fire department. Police. I'm not sure. I don't remember the police, but I remember the fire department coming. We brought them upstairs, and I said, "That's where the case is." So they approach, like all nervous. Like click it open it up. Guy looks at it, and he's like, he looks back at me. He's like, "That's a level." I was like, "It's dangerous." He's like, it's a level. It's a leveler. That's what it is. That's a level. So I was like, so it's safe. He's like, yeah, it's safe. It's safe. Oh God. Yeah. There you go. Anyway, I'll tell you. He starts looking at my pictures. He's like, these are all crooked. Yes. Yeah. Now you all know why I'm such a leveled guy. Oh my God. It was very, very humiliating. It was very, very humiliating. Yes. There you go. I was like, what do you want? Why would I ever see such a thing in my life? Why would if you saw that, you'd be like, I don't know what the hell that is. I don't know what that is. Anyway. I hope you enjoyed the show. Tomorrow, I'm bringing a guy in here. I think you're going to like him. I think he's funny. I think we're going to have a good time. I think you guys are all going to like him. You're not going to want to miss this show. So that's going to be tomorrow, hopefully starting at 10 o'clock. 10 o'clock. I thank you all for joining. I suck. Leave a comment if you think that was like is that like scale of 1 to 10 level of humiliation I should be feeling from that? Level of humiliation I should be feeling from that. I don't know. I don't know. It's pretty high. It's probably pretty high. That was bad. That was really thanks. I'm just a city boy. Love you guys. Have a good night and Godspeed.